they started here in Australia under what's called the Australian Courts Act 1828, Section 24. Okay, and that brought all of the laws of England into full force and effect throughout all of the Australian colonies. So that's where it sort of stems from. And then it was each state passed its own constitution, or each colony at the time passed its own constitution, and all of those parliaments that were formed were imperial parliaments.
Yep.
Okay, so the whole system was set up under the imperial heading. So the courts were set up, the parliament was set up, and the executive through the governors and the Governor-General as such, and the Queen, well, the governors, answerable directly to the Queen. So that was the go pretty much right up until Federation, and then Federation came in, and that's when it was enshrined into the Constitution.
Yep.
Under Section 108. So all of the laws that were inherited in the colonies were brought right through into Federation and imposed in all of the states. So there are two other sections of the Constitution of the Commonwealth which bring in those laws of England. The other one is Section 118, which is full faith and credit to all public acts and records and judicial proceedings of each state, as well as Section 51, subsection 25. So those three sections pretty much concrete into the law here throughout Australia that the imperial laws are here to stay.
Yes.
And they are beyond the power of any legislator in this country to repeal or amend, unless it be by a referendum first.
Yeah.
And because it's an imperial law, then those referendum results need to be taken over to Westminster.
Yep.
And then Westminster give the final change approval.
Yep.
So it's a bit more lengthy of a process to impose, to repeal or amend an imperial law.
Not just like what some magistrates try and do. Oh, no, the imperial acts were repealed in this state.
And as I will cite, actually, other states now have just distanced themselves from it. Here in Victoria, we have, this is where the imperial laws were brought in under one act in 1922 by Sir Leo Cousins. He was given the job in 1907 to put all of those laws of England together into one act, and it took him a long time, but he approached the Victorian Parliament in 1922, and it was passed as the Imperial Acts Application Act 1922.
Yep.
So then the other states sort of took it on board as well. Over the years, they were kicking and screaming, but regardless, they were there with it up until recently, of course. Up until recently. In Queensland, it's cited as the Imperial Acts Application Act 1984. In New South Wales, it's the Imperial Acts Application Act 1969. And in South Australia, well, that's where we've got to go for a bit of a search.
They like to do things a little differently over there, don't they?
Oh, totally. So they decided, in their infinite wisdom, their parliament still calls themselves an imperial parliament. But funnily enough, their imperial acts have sort of disappeared. They just disappeared off the database. Lost it. Just did anyone see that anywhere? No one saw it. Okay, well, guess it's not here anymore. So they cite it, and this is where, hopefully, if you've been to our seminars, then you would have seen us help you navigate a website called Austlii, AUSTLII. and it's quite a good website with respect to finding the nitty-gritty as such. And we urge people to go to their particular state, like, for instance, South Australia. You scroll down to South Australia Consolidated Acts. You click on that and you're confronted with an A to Z, and just above that there's this button, database search.
Yep.
So you click on the search and you just put into the search engine the word Imperial and hit search, and it comes up with a number of different acts where the word Imperial appears. But it's not the same force and effect that it was supposed to have. So you've got the Evidence Act 1929, it's cited there, it's cited in the Oaths Act and the Acts Interpretation Act. And it's cited in the Constitution Act of 1934, but again, it's only referring to this Imperial Parliament.
Yeah.
So it seems that they've let the laws slip past, but they're still calling themselves an Imperial Parliament.
I think the important thing to point out, is that just because a state doesn't have an Imperial Acts Application Act, it doesn't mean that the Imperial Acts don't still apply. And I think that was the point you were making earlier on. But I just want to make it very, very clear for people that the Imperial Acts are in full force and effect. The various state Imperial Acts Application Acts only, go to ratify or further prove and verify that those acts still exist.
Well, as you go through these searches and through the particular laws, and in particular the Acts Interpretation Act, it says that the imperial laws still have effect.
Yeah.
It's just that, hey, we've hidden them.
Yeah.
They're just not as obvious.
Yes.
So then we need to utilise Section 118 of the Commonwealth Constitution, and the most convenient place to the state to head to with respect to the law is Victoria.
Yes.
And Victoria has, because it was the first state to impose the imperial laws in an act as such, I mean, putting aside, we'll just bring you back to 1907. I mean, in 1901, Federation imposed the laws of England, concreted it into the Constitution. But they just thought in their infinite wisdom idea from 1907, we'll hand this job over to Leo Cousins and then he can put all these so-called laws of England together. Believe me, it wasn't perfect. No. He conveniently missed out some laws of England, but they're still there under the Constitution as such. So please don't let lawyers tell you otherwise. A good search through these search engines does expose these laws, and therein lies, as Mike mentioned earlier, the presumption of innocence and where that actually stems from. So it actually comes out, and this is where we urge people to go to the Victorian Act, the Imperial Acts Application Act 1980, and you'll see that it's only got 8 sections. You click on Section 8, and that brings up habeas corpus, freedom of election, and it's in habeas corpus, which is where the presumption of innocence is enshrined, and that's an inheritance through the Magna Carta, and that no free man shall be taken or imprisoned or diseased of his freehold or liberties or free customs, or be outlawed or exiled or otherwise destroyed, and that the king will not pass upon him or condemn him but by lawful judgment of his peers or by law of the land. And of course it goes further in to explain what those peers are, and those peers can only be good and lawful people of the same neighbourhood, where such deeds be done in due manner or by proceeds made by writ original at the common law, and that none be put out of his franchise or freehold unless he be duly brought into answer and forejudged of the same by the course of the law. And if anything be done against the same, it shall be redressed and holden for none. So, very, very straightforward sort of stuff, really. And this forms the foundation stone for the Bill of Rights and for all common law. And, of course, that common law must be maintained and cannot be fiddled with by these so-called corporate parliaments, because, interestingly enough, there was a High Court case just fairly recently, and it's sort of hasn't sunk into a lot of people yet. It's called the Queensland Rail case. But as Mike mentioned earlier with respect to that Government Act, the High Court held that, in fact, it backed up what that Act says, that, in fact, a body corporate or a body politic cannot be seen as a government entity.
Exactly.
So, and there's an admission with respect to local government in the Competition Consumer Act, Part 4, which quite clearly lays out that local government is defined under the cartel provisions within the Competition Consumer Act. So they are not part of government as such. And I know that there is somebody who's at the moment wanting to take this all the way to the High Court. And he's got good justification. There's a lot of law there that backs this up. These corporate entities that are masquerading as state, local and federal government, it has to stop.
Yeah, absolutely.
It really has to stop. We've woken up, well, the more of us the better, of course, but these imperial laws are there for good reason. They're there particularly to protect us from the exact sort of misbehaviour that is taking place around us now. The Bill of Rights quite clearly lays out that no one in government is to have any sort of allegiance whatsoever to the Pope, the Holy See, or any of the Holy See's supporters. So that's fairly straightforward. And everyone in government at any level, judges, it doesn't matter where you are in government, your oath and your allegiance is also spelled out within that Bill of Rights. If you haven't taken that oath or that allegiance, then you are quite clearly impersonating a public official, which is a very heavy penalty. So the people are waking up, and of course the way that they wake up is through these imperial laws. In Western Australia we have, we'll go to Tasmania down south. Now Tasmania, I've had to do a bit of a search there as well. Again, the imperial laws have, funnily enough, disappeared. But again, like I said earlier, we go back through the search engine. We put the word imperial in, and it comes up with a whole heap of laws: the Age of Majority Act, the Acts Interpretation Act, the Supreme Court Civil Procedure Act, Acts Interpretation Act, where the word imperial applies to a reference to an imperial act or a Commonwealth Act, so it pretty much equalises an imperial law with a Commonwealth law. So in that, but again, you can't rely on an imperial law as such in that state. You have to go to Victoria in order to bring about a greater definition of those imperial laws. And this is what it is our job to preserve these laws in order to maintain a public service. Not a public master. Which is what they're trying to...
nuisance.
A public nuisance. A public terrorist.
Exactly.
So...
extortionists.
Extortion. And there are a number of court cases that sort of back this up as well, other than Port of Portland versus State of Victoria, 2010 High Court, which upholds the Imperial Acts Application Act 1980 in particular for the State of Victoria as being a law. There's nothing in that law that is repealed or amended. It has full force and effect. So, true to Section 118 of the Constitution, it must be given full faith and credit. It is binding on all the courts. It is binding on all the legislators in this country. They cannot escape it. They try to fob it off. They try to say, oh, no, these laws don't matter anymore. They've been pushed aside. Really? Well, please show me the due process that allowed that law to be pushed aside, and we'll take it into the courts for review. And that's when they scuttle off with their tail between their legs. We've got Carr versus West Australia, 2007, and that really upholds the protection of the presumption of innocence. We've got Dietrich, which was a classic case in 1992 versus the Queen. So we've got the International Covenant on Civil and Political Rights. There's just so many laws and so many cases that, and of course, the one of the main principles is the Adelaide Steamship. In 1920, that was a classic. That really concreted within the courts, at least, that the obligation on the laws of England. So they cannot escape it, no matter what they do, no matter how much they huff and they puff. They cannot blow.
They do that a lot.
They huff and puff a lot. They do.
Lots of huffing and puffing. Lots of huffing and puffing.
And it also even appears, in one sense, in the Human Rights Act here in Victoria, 2004. I'm not a great fan of that act. It may have these common law principles enshrined within it, but I think it's under Section 30 or Section 33 of the Act. It pretty much claims that Parliament is sovereign. And that's just an absolute no-no here in Australia. No Parliament can exercise any form of sovereignty. They lost that ability at Federation. They all know it, and they're all trying to push that one aside as well. So, the imperial laws are very important for us to get our heads around, and like I said, the best one to go through to in order to understand those laws better is the 1980 Victorian Imperial Acts Application Act. It is just so much easier to navigate and is applicable in each state. And of course, that habeas corpus also in the first paragraph of that act mentions an act for regulating of the Privy Council and for taking away the court commonly called the Star Chamber. And of course the Star Chamber is what we're confronted with now with respect to all of these so-called courts in this country, all the way through. They're all inquisitorial. They're all denying our access to juries. They even have the star over the judge. They're quite blatant. The kangaroo and the emu and the star above the whole lot of them, it's just bizarre. They're not hiding anything, guys. No. And so this is why it's so important when you walk into those courtrooms is first and foremost you establish the jurisdiction.
Exactly.
If you see that star there, then you go, hang on, there's something wrong here. I just better check. Don't go forward with your case. It doesn't matter what you're in there for, whether it's a parking ticket or whatever. Establish the jurisdiction of the court first and foremost.
That's it.
Make sure that it's a court that's operating under Chapter 3.
Yeah, that's it.
All simple stuff, guys.
It is. It is indeed.